In this lecture, we're going to look at the way in which how dispossession or accumulation have actually evolved over a period of time, and by drawing upon the few literature review, and also move on to the land acquisition processes in India, and thereby looked into the various intricacies, the kind of land acquisition process which have evolved over a period of time, and also tries to critically look into it, to what extent it has in some way move on to the framing of different kinds of law. So, to begin with, let us familiarize ourselves with what accumulation is. Now, prior to this, it is in some way important to sort of look into that. Since the very beginning of capitalism, in land, land has been a major asset of production and accumulation of wealth. And as we all know, land is the physical place where production and accumulation takes place. For instance, the activities of mining, agriculture, industry, they all have actually taken place on a lot of or a surface of land. So, at the first stages of capitalism, as we all know, began in England, where the common land were being privatized. So, although these lands were the property of somebody, the commoners held certain rights to the land, such as producing of hay, grazing of livestock, and gathering of firewood. So, these rights were actually being taken away after forming certain kinds of restrictions or a kind of an enclosure. So, the owner had then all the rights of all the uses of the land, and the commoners in the process lost their way of living. So, this is one of the first form or the first examples of accumulation by dispossession. So, the all over the world, land actually is being bought up by big corporations, as we can see across the world, for activities, as I said, like mining, agriculture, and industry, are actually buying up land in developing countries. So, these are practices in search for minerals and arable land. So, one can actually see that how these accumulations actually takes place. As we all know, accumulation is one of the basic concept in which capitalism is primarily founded and based upon. So, it means that when the profit is made with capital or say labor, it gets reinvested in the production or capital assets. So, one of the reasons for this reinvestment is that these assets will in turn a profit in the return, which can be used to invest more money. So, this process of the vicious cycle is started, in which value is added to the total amount of capital in a certain place. So, that is the whole background or the way in which we can make sense of what accumulation is. Now, if we sort of tries to looked into the way how Marx actually tries to historicize or historically locate the way in which how accumulations have taken place. So, there are certain scholars who have actually made an extensive use of the concept of primitive accumulation and accumulation by dispossessions to analyze the way in which how land grab or land grabbing is being practiced globally. So, this very concept have been crucial to efforts to understand the land grabs in terms of the creation, expansion and reproductions of capitalist social relations, that is of accumulation by the extra economic means and of dispossessory responses to the capitalist crisis. Now, one of the if we sort of tries to locate the global land grab which feature in the academic literature is in some way the explanations of the post 2006 surge in large scale land acquisitions for especially crop productions and resource extractions in terms of the dynamics and contemporary transformations of what we generally understood as capitalism. So, two very key concepts scholars have actually used to understand the process are Marx primitive capitalism accumulation and David Harvey's terminology of the accumulation by dispossession. Now, if we sort of tries to look into the historicity, that is the very notion of this primitive accumulation, according to Marx, primitive or popularly known as original accumulation is the historical process of divorcing the producer from the means of production, and also creates the two bases of classes of capitalist society, that is the capitalists and workers, which is also known as the bourgeois and the proletariat. So, Marx's description of this primitive accumulation reveals a wide range of processes which can include the commodifications and privatization of land, which of course is pretty much rampant even in the millennia which we belong to, and also the forceful expansion of peasant populations and the forceful expulsions of the peasants populations, and also the conversions of various forms of property rights, that is both common, collective, state, etc., into an exclusive private property, that is the transformation from the commons to the private property rights, and also in due course of time it has in some way resulted to the suppressions of rights of the commons, which we have already discussed in the previous lectures about the common versus the private in terms of access to property rights. And more importantly, the commodifications of labor power and the suppression of alternative, more importantly the indigenous communities forms of productions and their consumption, and also the colonial, neo-colonial and the imperial process of appropriation of assets, which includes the natural resources, and also the monetizations of exchange and taxation, particularly of land. And also we have certain kinds of credit system which is a radical means of pushing forward the primitive accumulation. So, we have this in a nutshell we can sort of broadly try to look at the way in which how primitive accumulations can be described in some sense. Now, if we look further, that is the relevance of primitive accumulation and accumulation by dispossessions in terms of the analysis towards the land grab. one can actually see that the process by which land and other resources are enclosed and their previous users being dispossessed for the purpose of these capital accumulations are central to these to both of these systems. So many of the scholars who are critical or engaged with the land grab have actually noted the resemblance between many current land acquisitions and enclosures of land and dispossessions of peasants in England, and Marx had placed this argument at the very heart of his analysis of the primitive accumulations and the very origin of his idea of how capitalism or capitalist mode of productions have been explained. So these scholars who are done extensive research on this the global land grab or the land grabbing practices have actually linked today's new enclosures to the land seizures crucial to centuries of imperialism and capitalist expansion. So therefore, the role of the state is important here, because the role of the state in capital accumulation and dispossession is at the very core of both the theorization of these primitive accumulations and accumulation by dispossession and of the land grab research and practices. So primitive accumulation and the accumulation by dispossessions have been used to develop fruitful and theoretical informed accounts of the global land grab, and their use is also in some sense however fraught with challenges, and there are substantial tensions and ambiguities over their meanings in the foundational texts which is both posited by Marx and Harvey. So the debates over this primitive accumulation and accumulation by dispossession do not take place in isolation, but intersect with those over related concepts like enclosure, commodification, the double movement, neoliberalism, privatizations and capitalism in general. So therefore, there has been a proliferations in terms which are similar to, for example, accumulation by dispossession, including accumulation by displacement and displacement by dispossession by displacement and accumulation by encroachment, or accumulation by denial, or primitive accumulation by dispossessions and dispossession by accumulation. So further, before coming to what Harvey has to further explained about accumulation by dispossession, there can be in some way 4 uses which can be outlined. That is, there is a substantial way of variation in understanding the primitive accumulation and accumulation by dispossession in the land grab literature, in terms of both of how they are being conceptualized individually and of their relationship to one another. So let me just outline some of the way in which how these two are being described. The first project asks how capitalist social relations are actually being created by Marx's central questions in the sections of Capital on primitive accumulation, how they spread and how they are reproduced in the face of resistance and obstacles. So many accounts actually refer to the this process as primitive accumulation, although accumulation by dispossession is also used in this way. So, recent research extends to the way in which how the key enclosures involve well beyond land, and it is also largely being argues that primitive accumulation is not a finished historical stage in the real sense of the term, but rather it is an ongoing, and in that new people and resources are still being incorporated into the capitalist social relations, and in that those social relations need to be reproduced. So, one can see that such account actually focus especially on the enclosure of common land and the separation from the means of productions of the people who previously held or being dependent on it. So, the second main use of primitive accumulation and accumulation by dispossession has been to understand the capitalist responses to crisis, and one of Harvey's core projects was the new imperialism. It sort of like analyzes the way in which neoliberalism as a response to the over accumulation crisis that began way back in the 1970s. So, therefore, he developed the very concept of accumulation by dispossession to unite the way in which assets are being released at minimal cost through predations, fraud and violence, so that over accumulation accumulated capital can seize hold of and immediately turn them to a profitable use. So, Harvey highlighted the financial and the credit systems backed by the state power and also as mechanism of the accumulation by dispossession. So, Harvey also argued that the crises do not simply occur, but are actually being created and manipulated by the dominant states in order to facilitate accumulation by dispossession, which thus denotes a process and a kind of strategy. So, primitive accumulation and the accumulation by dispossession have also been understood in terms of extra economic means of capital accumulation, especially political and legal power and violent force. So, such extra economic means which allow resources to be forcefully expropriated and redistributed to capital are usually directly employed by state actors, although other organizations may also mobilized. Now, I'll come to the Michael Levin's important contributions in the later part of my discussion, and the way in which how these two premises has been explained and understood is that finally we can sort of argue and then point out that the primitive accumulation and accumulation by dispossession can be used without engaging with the broad theoretical questions. So, therefore, one can however imply that the two are more or less synonymous with enclosures and dispossession in general. So, if we further tries to elaborate and looked at the way in which the work of Harvey, the accumulation by dispossession is actually drawn from the idea of Marx analysis of this primitive accumulation, that is the historical process of how the producer is being pushed away or divorced from the means of production. And as we had explained some of the points, accumulation by dispossession, that is the neoliberal capitalist policies in many of the Western nations, that is from the 70s to the present day, as a result in centralizations of wealth and power. So these neoliberal policies are actually guided by few elements, that is privatization, financialization, management and manipulations of crisis and state distributions. So these are the four practices which perhaps guides the neoliberal policies. So accumulations by dispossession again can be used in order to explain further the variations in development in different regions. For instance, in resource rich regions in the global south, as we have sort of demonstrated above, it is not uncommon to see that the governments or corporations lay claim on areas which are inhabited or in use by mostly the local indigenous people. So one of the pertinent reasons why they lay claims in these areas is because these areas are rich in certain natural resources, and the capital that accumulates in these regions actually flows away to the corporations or the national government, and the local people don't see any positive changes as such because of the development that have taken place. So this is the irony, and then the other sides of the story in which how development does not really benefit the people. Now further, if we tries to look at the works of Michael Levin, where he has actually conducted an extensive field work in India and tries to look at the intricacies or the way in which how dispossession without development actually takes place. So in this particular book, which was published way back in 2018, Levin actually examines how the shift from the state directed capitalism to neoliberalism in India, which took place from the 1990s, has actually led to a new regime of dispossession in which land actually becomes for the market rather than for productions, and rural residents lose their lands and livelihoods. So based on the case study in a place in Rajasthan, this particular book was written in short, trying to look at the way in which how dispossessions actually takes place without any semblance of development. So in the dispossession without development, Michael Levin demonstrates how this shift, that is from the state directed capitalism to neoliberalism in the early 1990s, led to the genesis or the emergence of the regime of dispossession. So such a shift brings about the questions of whether dispossession of land by the government is predatory or beneficial for the national nation's development, as the discrepancy between the farmers' compensations with the market appreciations of the land is astounding. So Levin's theoretical engagement with classic to contemporary scholars and his employment of ethnographic insight exhibit a very insightful findings in which the global and local can be integrated into a sociological analysis. So two types of dispossession actually is being witnessed in the post-colonial India, that is the developmental and neoliberal. So what he pointed out is that during the developmental period, India actually engaged in dispossessing people of their land and for the public projects. Okay. However, the post 1990s actually see a kind of shift, that is the pressure of competition within the state and the temptation of legal and illegal rents provided the government with incentives to start dispossessing land for any reason that could be actually thought of. For instance, the special economic zones is one of them. So the dispossession of land in India actually have increased after the end of colonialism, despite a cry for a more significant reform. So land is actually legally permissible under the Land Acquisition Act of 1894, which was passed during the British rule, to take private lands by force for public purposes. However, after its independence in 1947, India set on the path of development, and it eventually undertook the Nehruvian model, which deepened the colonial legacy by perpetuating the exploitation of land and adding profit to private organizations without resettling and dispossess the resettling the dispossessed or the underprivileged. So development activities such as dams and which of course the one of the paradigmatic form of state-led development and potent symbols of national progress, were actually the largest source of dispossession in post-colonial India. So there was clarion call or a kind of appeal from the late Prime Minister Jawaharlal Nehru, which he sort of like told to the outstays of the dam that they should actually sacrifice for the nation, that is for the welfare or for the building of the nation. So one can actually see that the post 1990s, that is with the neoliberal reckoning, there is a demand for private land, and it has grown exponentially. So post liberalization growth was fueled by information technology and business process outsourcing, along with the multinational corporations which have actually tried to invest or intrude to the Indian soil. So one can perhaps think for a moment and tries to look at the way in which how this idea of how many companies have actually ushered in and then tries to bring the very notions of how development have actually comes into existence. So further, before we sort of talk about the land acquisition system, elaborating further on what we have discussed, Dispossession Without Development, the book which is written by Michael Levin, also talks about how the context of dispositions and also the major theories of disposition is being discussed, and Levin actually talked about the in depth of how the shift from state developmentalism to neoliberalism in India has dramatically changed the many of the state, particularly the Rajasthan state government, and which of course he called as land broker state. So the local government actually engage or in connivance with those companies which I have just read out, have confiscated around 3,000 acres of land to give to the MWC, which would then sell portions of the land to the private companies and build a high-end residential and commercial real estate. So it also outlines, the book also outlines historical perspective, that is the agrarian milieu of Rajpura village in the modern state of Rajasthan, that is discussed all throughout the book. So Rajpura, if you look at, is a monsoon dependent village with a population reliant on diverse farming. So a combinations of a strict caste systems and political separations before and during the British colonizations have actually rendered the people in this village without a historical tradition of fighting for themselves and also collectively organizing uprisings or protests. Therefore, it was easy for the Indian government to actually set up a special economic zone in 2005 and also take advantage of land without much resistance. So one can actually see that Levin actually uses the case study of Rajpura in Rajasthan to effectively or to bolster his argument by establishing that India's transitions from a development state to a land broker, one for private industry, was made possible by the state agencies. So instrumental in this transition was the large-scale dispossession of rural Indians, particularly the indigenous communities, a practice that increased significantly as India continued to liberalize throughout the 2000s. So one can see that the book actually engages with a profound or a deep insight about with based on the ethnographic study, and try to look at the intricacies, the way in which how the state promote private companies or privatization of land, and actually the people who are in the receiving hand are actually bearing the brunt of those issues. Now coming to the story of land acquisition in India, the very notions of these land acquisitions in India as a systematic process carried out under the sanction of formal state structure is again the Colonial Land Acquisition Act of 1894, a colonial law which actually brought into practice by the then British government. So one can actually see the systematic dispossession of peoples from their lands, which has actually a longer history in colonial India, and even it has continued till today outside the ambit of law. So the colonial law of 1894 continued to be used as one of the principal law used for the purpose of land acquisitions for the development projects, a term that has been interpreted as widely as ever over the course of time until as recently as 2013. So if one has to make a close examinations about the Land Acquisition Act of 1894, which of course is a key to understanding the legal and institutional framework employed by the state in matters of land displacement and development. So in principally the very phrase that is public purposes has been actually elaborated in the Land Acquisition Act 1894 under section 3F as including the need for sites of planned development, extension or establishment of new villages, town planning, pursuing a government scheme or policy, housing for the poor and or people affected by the natural calamities, building of public or government offices, and for any other development scheme or plant, including constructions of railways, irrigations, canals, etc. So the Act further includes companies and therefore private capital within its ambit, so long as prior consent of the government has been acquired and it is likely to prove useful to the public, which is spelled out in section 40b. So section 5a of the Act again makes provisions for objections that may be registered with concerned state authorities within 30 days of publications of the notifications. However, this section is overruled by an urgency clause. The exact definitions of what constitute as urgency remaining ambiguous. So under the urgency clause, there is little space for dissent and objections. So on the resolutions of such objections, declarations of the proposed project is put forward by the state authorities, serving as evidence that the land required is for public purposes. With this, the process of acquisition is set into motion, and a matter of compensations and identification of persons who are to be compensated actually begins. So these are some of the provisions within the law, to deal with individuals who may actually oppose the said land acquisitions and prove to be an obstacle in such a process, mandating government officials assisted by the state police forces to enforce the surrender of such land. The law therefore institutes and sanctifies the absolute authority of the state in forcibly acquiring land, codified in phrase such as compulsory nature of acquisition and forced surrender of land. So if we further looked at the Land Acquisition Act Amendment Bill 2009, so following the sustained criticisms of say the Land Acquisition Act 1894, most significantly from people's movements protesting forced land acquisition, but also evident from several court rulings recognizing the undemocratic character of this particular act. So in 2006, the National Advisory Council (NAC) drafted a national development, displacement and rehabilitation policy. So this document drew heavily on a draft presented by the National Alliance of People's Movement. So the National Alliance People's Movement is again an umbrella organization of several people's movement organizing around the questions of land and livelihood, and its draft to the NAC followed a series of consultations with its various constituencies. So in 2009, the Land Acquisition Act Amendment Bill and Rehabilitations and Resettlement Bill were introduced in the Parliament, but were not actually passed owing to oppositions both within and outside the Parliament. However, several key changes were proposed in the law under the Land Acquisition Act Amendment Bill of 2009, which actually broadened the categories of persons who could actually claim compensations, including the tenants who actually work in the agricultural land in questions, as well as the scheduled tribes and other traditional forest dwellers whose traditional rights over forest lands may have been lost which are of course now recognized as under the Scheduled Tribes and other traditional forest dwellers Protection of Forest Rights Act of 2006. So this was in some way an important change in terms of attempting to recognize not only those who had proprietary rights over the land, but also those whose livelihood practices were to be actually affected. Yet again, the fresh public purpose that continues to remain a controversial, fresh and one that is at the heart of much debate till today, and which came to be elaborated in great detail under the proposed amendment. So these include a range of activities from military and defense purposes to infrastructure and industrial projects, including activities such as mining. It also introduced the centrality of rehabilitation and resettlement, and not mere monetary compensation as integral to the responsibility of the state. So these include responsibility for developing the infrastructure of rehabilitation sites, including assuring proper health and education. Where the number affected is say greater than 400 families in the plain and 200 families in the rural areas, the LAA amendment bill introduced the requirement of again social impact assessment report by taking into considerations or keeping in mind marginalized communities in particular. So the proposed amendment further brought to the for the need to desist from acquiring irrigated multi-crop agricultural land and made a provision to follow the principles of minimum displacement. So next to what we have discussed, that is the Land Acquisition Act of Bill of 2009, we have the right to fair compensations and transparency in land acquisition, rehabilitations and resettlement act of 2013. So if you look at the history of how this act have come into existence before it was being finally passed. So in 2011, on the recommendations of the NSC, that is to combine the two bills, a comprehensive land acquisition, rehabilitations and resettlement bill was introduced in the parliament to replace the existing Land Acquisition Act 1894 and bring the process of land acquisition and subsequent rehabilitation of the affected populations into the ambit of one single law. So certain key new elements were introduced in this bill, which include the increase in compensation values to 4 times the market price of land in the rural areas and 2 times the market value in the urban areas. So while it limited the acquisitions of land for public purposes only, it included private companies as well as public-private partnership projects within the ambit of the law, requiring the consent of 80% of displaced people in this case. So the consent was actually be routed through the the Gram Sabhas or village assemblies as per the existing Panchayati Raj institutions and laws, including the PESA, that is the Panchayat extension to scheduled areas. So, however, the law would actually apply social impact assessment was actually conducted in case of land acquisitions. However, the law would not apply in the case of acquisitions under 16 existing law laws including the Special Economic Zones Act 2005 and the Atomic Energy Act 1962 and other similar acts. So this bill was far more comprehensive bill, taking into account several of the key demands of displaced and affected populations, and not merely the landowners, by making the state as well as the private companies responsible for the rehabilitations and resettlement with proper infrastructure and basic services in place for the to be affected populations. So despite significant new features in this bill, it continues to have certain problems, including the manner in which the public purpose remains a fluid category, allowing any kind of private industry to flourish in its name, and consent in case of public projects is not required. No rehabilitations and resettlement provisions are mandatory in the case of temporary acquisitions of land for up to a period of 3 years. However, it was in fact a move ahead in terms of establishing certain structures or in place such that the interest to be affected populations are actually taken into considerations to a large extent. So the law was actually finally passed in 2013 and which came to be known as the right to fair compensations and transparency in land acquisitions, rehabilitations and Resettlement Act 2013. So it sort of created exceptions for a range of acquisitions for which and social impact assessment and informed consent was not required, including projects in for example mining, railways, electricity and national highways. So at present we could actually say that this is the law that governed regards to land acquisitions for the purpose of under the development projects. So one can actually see the various nuances in terms of the controversy which actually arises, that is from the days of the colonial era legislations, that is the Land Acquisition Act 1894 to the present day of the right to fair compensations, transparency in Land Acquisition Act of 2013. So the controversies and confusions have actually clouded the process of acquisition, and also in terms of fixing of the quantum of compensations in any land acquisition exercise for development projects of both the state and the central governments. So in 2012, the Supreme Court actually directed the state to enhance compensation to the highest market value of the land to any unwilling landowner, but the government does not seem to have taken a serious note of this. So most often time the problem arises in terms of the catering to the compensation. So the right to fair compensations and transparency in the Land Acquisition, Rehabilitations and Resettlement Act 2013 has addressed the long-standing asymmetries of power between bodies, power between the acquiring bodies and the affected people, by injecting some amount of transparency and fairness in land acquisition, though the provisions of market link cash compensation, social impact assessment, resettlement and rehabilitations. So, the experience, however, the implementation of the Act has been checkered. Social impact assessment, for instance, which was widely laudable mechanism for guaranteeing participations of affected people in the land acquisition process, has been perceived as cumbersome process by mostly the industry and some state governments. So, a few states have actually excluded a large category of projects from the ambit of the social impact assessment by enacting amendments after taking recourse to Article 254 2 of the Constitution. So, the capacity deficit of SIA units, SIA agencies, district officials and acquiring bodies remains a matter of concern. Then the issue of livelihood generations of project affected people requires closer attention. So, rehabilitation activities can make meaningful contributions on the when they become a distinct part of project designed with sufficient allocations of time and resources. So, there is also an urging need that an emphasis should be actually made, needs to be placed on the skill developments of the affected people, and financial literacy camps for the recipients of the cash compensations can actually encourage investment of compensation amount in income generating activities and productive assets. So, it is also important to see that the state of land record is an area which require immediate attention, because the outdated and the poorly managed land records creates often disputes and complicate the land acquisition process. So, the updation of the land records and their computerizations, as well as the adoption of conclusive titling, actually is also one of the need of the hour. So, the perceived difficulty of acquiring land under this Act, the RFCT LARR Act 2013, has actually created interest in alternate options of land procurement, that is through direct purchase, pooling and leasing. Here again the land record management is critical. Of course, the success of the alternatives hinges on creating suitable policy and regulatory frameworks by enacting new laws and repealing or amending the existing laws in states that often work at the cross purposes. So, the provisions of transferring cash compensations in the joint account of households actually is also one of the ideas of moving forward. So, they also renewed the focus on the issue of availability of land, which has actually led to calls for land use policies at the national and the state level that can actually provide roadmaps for sustainable applications of land in consonance with the needs of the industry, interests of communities and requirements of food security and sustainable development goals. So, there are also certain kinds of challenges pertaining to the Land Acquisition Act of 2013, that some of the limitations which are being pointed out is that the Central Act of 2013 was brought to give effect to the pre-existing fundamental rights to livelihood of existence, and it ensures that livelihood will not be taken away unless it is in public interest and that is seen by social impact assessment, and the affected citizens are given rehabilitations. So, the amendments made without considering the above factors will take away the fundamental rights of the citizens. So, also in terms of the compensation again varies with the market rates, and in the case of the rural area it is four times and 2 times for an urban area. So, affected there is also a provision for rehabilitations and resettlement award, which includes employment to one members of affected family. So, these are some of the pros and cons of this Land Acquisition Act of 2013, and while comparing with with some of the earlier act, more importantly the Land Acquisition Act of 1894, there is a lot of scope and then improvement in terms of how the for instance the social impact assessment and special provisions for safeguarding food security. These are some of the new fresh insights in the content of these particular acts. So, we can sort of try to sum up and summarize by trying to see the way in which how dispossession by development or maybe accumulation by dispossession and by trying to use the very notion of primitive accumulations and then trying to look at how capitalism has actually evolved and the manner in which land grabbing actually happens globally, and then what are the push factors and who are actually the beneficiaries. So, then we also come to trying to look at the way in which how land acquisition is being carried out and what are the state policies in India. So, to some extent we can sort of try to relate that how dispossession and or in terms of acquisitions of land, because land of course is one of the most valuable component in terms of how capitalism is being carried forward. So, we can further try to make sense of understanding or notions of these dispossessions, displacement, or maybe in terms of land acquisitions and procurements of lands for the public purpose, the various dichotomies, the intricacies and debates further by referring some of these readings. So, I'll stop here and thank you.